Good morning. Actually, uh, when we get the order for eviction, uh, when we approach rent control authority, pending enquiry of the lower court rent control petition, there is a provision under section 11(4) and the Tamil Nadu Buildings Lease and Rent Control Act and corresponding section after new act come into force. But here is a case where Supreme Court has given a different ratio in respect of pendency of appeal and revision. What amount must be payable to landlord? Before that, it's a case AR 2022 Supreme Court 5756. AR 2022 Supreme Court 5756 Summer Corporation vs. Vijay Anand, Gangam and others. This case where it was filed under Bombay Rents, Hotel and Lodging House Rates Rent Control Act. It is not Buildings Lease and Rent Control Act. This act is 1947. See here what actually happened. There was a lease for initially for 30 years and subsequently that was in the year 1949. Subsequently the lease was extended for 98 years in the year 1968. Then the lessor died, lessee died, and so many things were there. Thereafter the lessor died, seems to have filed constitute a trust filed eviction, and the lower court allowed the original petition and ordered for eviction. Then against that appeal was filed before the appellate bench of the small causes court, and thereafter revision has been filed before the High Court. Actually, the lower small cause court disallowed the petition for eviction. It is appellate court allowed the appeal and by setting aside the trial court order. Then the lessee, namely the tenant, seems to have filed a civil revision before the revisional court of High Court. Therein, High Court has fixed a rent to deposit rupees 2,50,000 per month towards the compensation as a conditional stay. You kindly, the Supreme Court now held by referring judgment of Atmaram Properties Private Limited as well State of Maharashtra vs. Supermax International Private Limited. Therefore, you must kindly, the ratio was that the compensation should be calculated and fixed at the rate if the lessee means tenant evicted and that premises is leased out subsequently, that rate should be calculated. I think you understand it. Normally, he should not be allowed to pay the rent as he was paying earlier. He must pay the rent if after the date of eviction, if the premises is let out, what would be the expected rent if subsequently let out, that means a ratio. So you can apply this in our RLTOP cases. I hope you understand. Therefore, you follow the judgment, keep the judgment on file and record. Best wishes.